So can I again welcome everybody to this Early Permanence Law and Practice webinar. My name is Carol Atkinson. I am the designated family judge for East London, which is, as many of you will know, is 1/3 of London. And I always like to say is the biggest in terms of volume. And I'm afraid to say in terms of wait time, it may be. So we're a very busy court, and I'm delighted to have been invited to chair this meeting. We've got a really interesting webinar this evening, which is intended to really excite interest in early permanence. I hope bust some myths about it. I've been involved with one of these webinars before, and I just want to say that it's always struck me that at its simplest, like many good ideas, early permanence is a truly simple idea, isn't it? And as many simple ideas, it's a very good idea. When circumstances combine to justify the removal of a child from its parents, pending a best interest determination by a judge, then placing that child into a family who will care for him or her and either facilitate the return of that child to a parent, if that's the decision of the court, or alternatively provide an alternative permanent placement for that child, so that child does not have to move on to another placement, is surely something which we should all be striving for. And in fact, as will be explained in due course, it is enshrined in the legislation and has been for some considerable time. And yet it seems to be something that's quite difficult to achieve. And I hope that in November, when you see the patterns of early permanence in London, the research project that's been commissioned by CORAM, you will see what the barriers have been in London, and they're probably more widely applicable. The truth is that whilst it's a simple concept, it's quite complex to get up and running. It requires commitment. It requires an understanding of the concept, and I think probably people to champion it. It requires communication between all of the key people. And I think it requires a bit of education, because for some people, early permanence means an early decision about adoption, and it doesn't actually mean that at all. And I'm hoping by the end of this, when we get to the Q&As, that will be clear. So that's pretty much all I want to say as an opening gambit. I'm going to introduce our speakers as we go along. I'm hoping they're all going to keep to time. I won't be too tough on them, but I might give a reminder if we're running close. The programme is that we're going to have, first of all, we're going to have some information from Jane Poor, who is an adoption consultant with CORAM Bath, and she's going to give us 10 minutes about the fundamentals of early permanence. So here we are with our education straight away. Jane, can I hand over to you?
Hi, good evening. Everybody hear me?
I can.
I'm going to share my screen, hopefully, so someone can give me a thumbs up when we're, and then if I, that okay? Are we on slideshow from the beginning? Excellent. Yes. Thank you. So yes, fundamentals of early permanence in 10 minutes. I think that's a challenge in itself, isn't it? Welcome everyone. So I think when we're talking about early permanence, one of the first things that always comes up are definitions and phrases. And is it concurrency? Is it fostering for adoption? Is it early permanence? What's the difference between them? Well, the truth is that most children who come into foster care actually return home to their parents. All early permanence placements seek to prevent changes for the child. So we're trying to reduce the number of placements that a child has during the proceedings. So they all, whether it be early permanence, concurrency, fostering for adoption, they all place the child with an approved adopter who fosters the child for the duration of the proceedings until the outcome of the court is decided, at which point they may return home to their parents, they may return to family in the form of a kinship placement, or they may actually stay where they are and they're unable to return home, in which case the foster carers will go on to adopt them. So that's the principle behind them all. Concurrency, there's not as much concurrency around in the UK at the moment. We are seeing less of it. Concurrency always had a detailed rehabilitation plan for the child to return home, but the child was fostered, and the foster carers supported that plan to go back to the family. If that plan didn't happen or didn't work out for whatever reason, they would then go on to adopt the child in their care. Fostering for adoption, in theory, the key principle is that the local authority will have already determined that the child's unlikely to go back to the birth family. In actual fact, that applies equally for concurrency, otherwise they wouldn't be placing them considering adoption for them in the first place. So but fostering for adoption, everybody's been ruled out as far as they can tell so far. So there is no active plan, although obviously the local authority continue to work with the birth family throughout the proceedings, and they will continue to support them and try and help them turn their situation around and have the child back in their care if that's at all possible. Where it gets a bit confusing is that one can change into the other. So concurrency, we can see that whilst it may start as a concurrency placement, then birth parents drop out, they're no longer able to continue their part of the plan. And so you're left with a child in a placement that actually essentially looks like a fostering for adoption placement. Vice versa, fostering for adoption, there is no identified alternative at the point that the child is placed. However, as we all know, we've all experienced, other family members appear, putative fathers appear, and then are assessed and may go on to have residential placements. So what you end up with is fostering for adoption placement that looks like a concurrency placement. So early permanence covers both of them. Early permanence is an umbrella term, and it covers both fostering for adoption and concurrent planning placements, concurrency, and they both aim to place children while the courts consider whether they can return to the care of their family. So we know that moves are damaging to children. We know that however young, however planned, whatever the smooth transition is, moves of primary carers and placements do not end up with good outcomes for children. And the more moves that they have, the more detrimental it is to their, as they grow up, their attachment, their inner working models, their ability to form relationships, and their capacity to trust. We know that children who have multiple placements have negative impacts on their cognitive and emotional development. So what we're trying to do is minimize the number of moves for the child. And early permanence does that because it means that the child is in the same placement throughout the proceedings, and may go on to be adopted by the same carers if that plan becomes one of adoption. So it's the adults that are taking on the uncertainty rather than the child being moved. So I'm just going to move my, sorry, I've got my nice gallery with all you lovely people on over my notes. So the advantages for the carers themselves, they have an opportunity to form early attachments with the child. Very often it's very young children, babies straight from hospital, and they get that opportunity to form those attachments very early on in the child's life, which is beneficial for them as the child grows up. One of the other things it's good for is it gets to demyth the birth family. So rather than any preconceived ideas or you know, what people think about the birth family, they actually meet them. They often share ongoing contact sessions, direct sessions where they meet up and stay in touch with their birth parents. And they're able to understand why the birth parents are in the situation that they are more. They're able to exchange information. And quite often they will then go on to maintain that relationship long term. And I've got some examples later on from a piece of research that's been done in the University of East Anglia, which just some little quotes from birth parents. So it supports the future relationship for the child, and it also supports the relationship with the birth family. And even if they don't go on to have ongoing direct face-to-face contact, they still know who those people are, and it supports that communication of information. And so there's a relationship established. I think somebody said at the conference a few weeks ago that even if you never meet your child's birth parents, you are still co-parenting with them. And I think that is a fantastic concept that we need to hold on to. So as foster carers, EP carers look after someone else's child on a temporary basis. They are foster carers in the same way that every other foster carer is a foster carer. They work in partnership with the local authority and the birth parents, often attending contact sessions and meetings. They complete weekly logs and records and paperwork in exactly as the same way that foster carers are expected to, and they also attend reviews and other meetings. They're allocated to the local authority fostering team, and they're given access to fostering training, which is specifically for foster carers. And they contribute to life story work, memory boxes for the child in their care, which then go back to the birth family if that's the right placement for the child. These are some of the, I can't spend long on this slide because we haven't got long, but qualities we look for when we are assessing and approving early permanence carers. We always say it's all the qualities you would hope of an adopter, but with bells on. We need them to have these qualities in abundance. Certainly the capacity to deal with uncertainty, the uncertainty that a child may stay with you, but also the uncertainty around how long the court proceedings are going to be, the uncertainty of managing contact, how plans change, being flexible and able to respond to the demands put on you, and able to accept that lack of control. I think is quite an important thing. If you like to be able to make decisions about everything, then this probably is not the scenario for you to go down. And it's not for everyone, but where it works really well. And finally, these are some, Ruth Copson at University of East Anglia is doing a PhD. She's just about finished. She's writing it up into contact in early permanence placements. And these are some of the things that her lovely birth parents have written in her interviews with them, talking about how they really didn't like the idea of their child being in this placement, but they got to know them. They could see the benefits of early permanence. These are people that have often been in through the care system themselves. They know what it's like to have had multiple moves and experience that. And so they understand the benefits of staying in one place. And we often get to the end of proceedings, and if the plan is one of adoption, then birth parents often say, can they stay with the foster carers that they're with? We know that, and what we're actually doing is building in a process for them to be able to do that. There are some more of these, but I'll send the slides out as we go at the end, so that you don't have to. There's quite a lot on the screen there. And that's me. Thank you very much.
Thank you very much, Jane. That's excellent start. Great comments there. I'd be interested to know what's going to happen to that piece of research. It would be useful to be able to disseminate that information, that PhD information, as amongst the judiciary or more widely.
There is a learning from research session at Coram Bath, which is planned in November, and I'm sure Liam will be able to stick the link in the chat for people to access that.
Brilliant. Well, thank you very much.
Running that.
Great. So that brings me on to our next slot. That's Alexandra Conroy Harris, who is a legal consultant for Coram Bath, and Alexandra is going to tell us about the legal elements of early permanence. Alexandra. Are you on silence? There we are.
Right. Can everybody see that? And can everybody hear me? I'm getting nods. Excellent. Always a good start. Right. Early permanence, where we came from. And I think it is worth looking at where we came from and why we started the obligation to look at early permanence. So we had concurrent planning, which came into the UK in the 1990s. It started in America, and there were various projects set up in England. There was the Goodman Project in Manchester, Coram in London, Brighton and Hove set up their own scheme, and various other local authorities, to a certain extent, that started implementing this idea of concurrent planning. At that time, it involved dual approval, full approval as foster carers, full approval of adopters before children could be placed. So we come to about 2010, 2011, and the government was extremely concerned, as they periodically are, about the delays in childcare proceedings. This was before the introduction of 26 weeks, so there were stories of very young children being involved in cases that were taking over a year sometimes. And I'm afraid, for various reasons, in some areas, we're getting back to that sort of situation. So as a result, children were being placed for adoption older, which we know is not constructive in terms of their attachments to new families. And they will have experienced multiple moves before they get to their permanent family. So the suggested solution had family justice review, the NARI report, an action plan for adoption. The suggested solutions, which were enacted in the Children and Families Act in 2014, were support for fostering for adoption, just to make it clear that it was a lawful process and can be encouraged, and a statutory 26-week limit on care proceedings. Those were going to solve the problems that we had. So the Children and Families Act amended Section 22C of the Children Act, and initially, our suggestion, Coram and Bath, or Bath as we then were involved in making suggestions as to how we could embed fostering for adoption. And all we really wanted was for the Act and guidance to make it clear that this was a lawful option. that could be considered. And the DfE actually went a step further. And where a local authority is considering adoption for a child, the local authority must consider placing a child with an individual who is a local authority foster parent who has also been approved as a prospective adopter. And it's an absolute obligation. If you're considering adoption, doesn't mean that the decision has been made, doesn't mean you've had a best interest decision, doesn't mean you've got a placement order. Just when you are satisfied, and there's so many cases, if you're going into proceedings on a very young baby, you've done a lot of assessment beforehand, you've got to know that the chances are, there are very strong chances that this child is not going back if the pre-proceedings work has been done. And social workers will know the children that they think are not going to be able to return to their birth families. And adoption is one of the primary outcomes for the child. That's considering adoption. And you have this absolute duty. The local authority must consider placing the child with a local authority foster placement who's also approved as a prospective adopter. And that's also included in the statutory guidance. The local authority may still be considering other options for the child, may still even be attempting rehabilitation, but expects that adoption will become the plan should those alternatives not succeed. And the local authorities must assess the appropriateness of placing a child in a fostering for adopt placement with duly approved carers. It's not an add-on, it's not a nice thing to do if you've got the time and the resources. It's something local authorities must follow and consider. We've also got the corollary statutory guidance saying that agencies approving prospective adopters should ask them whether they might be interested in fostering a child under a fostering for adopt placement. And you don't have to assess and approve the prospective adopter as a temporary foster carer at the same time, but it's something that should be introduced into the training process. And I think some areas now put all of their prospective adopters through fostering for adopt training, so that they're aware of the program, aware of the advantages for the child, and also aware of the advantages for them. As Jane said, it isn't for everybody, but the more people find out about it, the more people are likely to volunteer. I think one of the original objections to the idea of introducing fostering for adoption was the idea that we would never get carers to do it, because you're putting yourself at huge risk of the trauma of having a child that you've committed to and were hoping to adopt not staying with you after the end of proceedings. But there is an astonishing number of people who are actually willing to do that. And that's the program, that's the plan, is to put the risk on the adults rather than the child. The child's got no idea that their legal status is changing. All they know is they're in the same placement and continue being in that placement, and they don't have to leave and move on to another carer. And in order to make that process slightly easier, to avoid having to approve somebody as a foster carer as well, the care planning and placement case reviewing regulations were also amended to allow the local authority responsible for a child to approve a prospective adopter temporarily as a local authority foster parent, if that's in that particular individual child's best interests. And that temporary approval period sometimes gets mixed up with temporary approval of connected people. It's completely separate. There is no time limit. It's just a one-off approval and placement of a child as a temporarily approved foster carer. And just to reinforce the need to consider it, it's in the C110A form. You are asked right on page 1, is the local authority considering adoption? And I've got to admit, when I work for a local authority, we quite often tick no on this one, because the next question is, we'll go and fill in the next section, which says, well, where's your application for a placement order? And they're separate bits. You can consider adoption for a child before you have the best interests decision or the authority to apply for a placement order. So you should be ticking, when it's appropriate, that box saying, yes, this child is possibly the possible outcome or a likely outcome for this child is adoption. And I think it would be really helpful if judges and guardians looked at that box as well and said, has it been filled in? Has it been ticked? And if no has been ticked, why? What are the realistic alternatives, particularly for very young children, that you're thinking of pursuing if you haven't got a family placement? But it's not inconsistent to tick the box on the front of the form that says the local authority is considering adoption, but also then to say they're not considering it to the extent that they have achieved best interests or that they are issuing a placement order at this stage. But I think it just indicates the importance. It's right at the beginning that the question is asked. Carers, early permanence carers, are foster carers, pure and simple. They are foster carers until they're matched to the child as prospective adopters and they're notified of the date on which that child will become placed for adoption by the ADM. Until those things have been achieved, and of course that can't be done until the child has a placement order or has consent of the parents to be placed for adoption. So until that's done, the carers are foster carers. They're not prospective adopters. They're not even prospective adopters. They are foster carers. They can be duly approved, so they can have gone through the full fostering training and approval. I think that's sort of seen as the gold standard. I know Quorum in particular do that. They approve carers as foster carers and as adopters, or they can be temporarily approved under the care planning regulations. There is no particular status because they are also EPP carers. There is absolutely no difference in their duties as foster carers and their rights or lack of them as foster carers. The local authority still has a duty to consider any family who come forward. The Section 22C duty to prioritise the family placement continues throughout proceedings. The fact you've placed a child with an early permanence carer doesn't end that duty. If an appropriate family member comes forward, that child has to be moved. The family take priority. The only difference between early permanence carers and other foster carers is that the shared parental leave regulations have been amended in order to define placement for adoption for the purposes only of adoption leave and pay is the point of early permanence placement. And that's simply because if you didn't do that, if you left everything at the point of matching before adoption leave and pay kick in, you would never get any employed person able to take up early permanence, to offer themselves as early permanence carers, because they wouldn't have any job security, they wouldn't have any adoption leave. So that is a difference, but it is the one and single difference. We've got solid case law dating back to 2015. RETI, there was this shortly after the Act was changed, and I think possibly this was local authorities rushing into early permanence without having fully prepared the early permanence carers. So you had a child placed from hospital the day after birth, was placed with the parents' agreement, Section 20, with early permanence carers. Within a month, an ICO was obtained, and in the course of those proceedings, a DNA test was obtained which confirmed paternity, and the paternal grandparents put themselves forward as carers once they knew that they were actually the paternal grandparents. And after a positive assessment, the local authority changed their plan from adoption to family placement with the paternal grandparents, which devastated the early permanence carers. They weren't expecting it. They thought that having had this child placed with them, this child was going to be their child to adopt and to keep as theirs for life. And at first instance, the judge allowed the application for leave to issue the application for adoption. They hadn't been there a year, they needed leave, and also join them to care proceedings. And it was really giving her, there was a logic, it was to give her the evidence of the potential carers for the child. So whether the paternal grandparents or the EP carers were actually going to be the better people to care for the child. But Court of Appeal allowed the local authorities appeal. It was completely the wrong question being asked. So the first question is, does this child need to be placed outside their birth family? And if the answer to that question is no, because there are paternal grandparents who can look after that child, then we don't go on to look at the early permanence carers. They've got absolutely no rights to be considered. And quotes from the Court of Appeal: there's nothing in the recent case law on adoption which justifies, let alone requires, any change in approach. There's nothing in the status or function of early permanence placement foster carer which justifies or requires any change in approach. Moreover, there's a very real risk that if the forensic process is allowed to become a dispute between the prospective adopters and the birth family, the court will be diverted into an illegitimate inquiry as to which placement would be better for the child. That, it cannot be emphasised enough, is not the question before the court. And it does continue needs to be emphasised. It still needs to be emphasised. These carers had the child from birth. By the time we got to the Court of Appeal, the child was 8 or 9 months old. They'd been looking after the child brilliantly for 8 or 9 months. They committed to this child, and it was completely irrelevant because family members come first. And the fact they were being approved as early permanence carers gave them absolutely no status in terms of being considered for that child, for carers for that child, any more than any other foster carer would have been. And the court also noted that what they said that I hope is obvious, in every case of early permanence placement, it must be completely clear and supportive of the carers, so they understand what they're letting themselves in for, the risks they're taking, and the fact that that child could be moved on if appropriate. Another case the other way around, they had a child placed with early permanence carers, and in fact, even before the child was born, an aunt had come forward and had a positive viability assessment with some concerns, but the local authority, nonetheless, when the child was born, placed it in early permanence placement. The aunt had a full positive kinship care assessment, and then an ISW report who said that they felt that the best option was adoption, given his attachment to the early permanence carers, although they did agree that aunt would be able to meet his needs. And the court was, again, completely clear: the foster to adopt placement does not give any precedent or any rights to his current carers, or require me to carry out an assessment of their individual qualities as carers. And that child moved to the relatives. Because the local authority hadn't done that beforehand, that child, of course, had longer in their early permanence placement, but it should have moved earlier. It's very clear, and I don't think there should be any doubt now that there is nothing in the early permanence placement which gives any priority to the carers, gives any rights to the carers, or preempts the final decision of the court in any way, shape, or form. And that needs to be hung on to their pure and simple foster carers. Given that they're foster carers, we now have a situation where in some courts, there's a lot of pressure being put on local authorities where the courts and the guardians don't like early permanence. They still have a feeling that it's preempting the decision and that the family is being disadvantaged in some way by the fact that the foster carer is looking after the child, would be able to keep that child long term if the child couldn't return home. And we're having to go back to 2002, remind courts about these starred care plans, which you may or may not remember, caused chaos for a certain amount of time in 2002. Bright idea of the Court of Appeal to identify specific aspects of a care plan and say that if the local authority didn't meet those aspects of the care plan, then the local authority would have to report that fact to the guardian and possibly return to court. And the House of Lords are completely against this. The quote is: "The Children Act delineated the boundary of responsibility with complete clarity. Where a care order is made, the responsibility for the child's care is with the authority rather than the court. The court retains no supervisory role, monitoring the authority's discharge of responsibilities." That was the intention of Parliament. Local authorities, not the courts, have responsibility for looking after the children who are subject of care orders. And just to emphasise the decision of the President, and it's Justice Mumby when he's the President, it's a Cardiff case, that's why I got the Welsh Dragon in the corner, just goes over this, all the case law, which is quoted back then, going back for years. Very clear cardinal principle of the Act: once the final or interim care order has been made, then it is for the local authority, not the court, to decide how to meet its parental responsibilities for the child, including where the child lives, and the general welfare of the child. So the decision as to which foster placement a child goes to is for the local authority. It's not for the court. It's not for the guardian. And that it's a shame that it still needs banging home. It still needs to be emphasised. Local authority has the right to decide which foster placement they place the child with. Early permanence carers are foster carers like any others. That choice is one for the local authority, and they have a statutory duty. More recently, what we're finding, I think, anecdotally, we're hearing that judges are not making orders prohibiting placement with foster care, specific sorts of foster carers, because they can't. But what is happening is they're putting pressure on local authorities. So this case in 2021 went on for a long time because they were, the child was placed with foster carers at birth. The father was misidentified, lots of delays. Paternal relatives came forward once the father had been properly identified, had a lot of assessment, but the foster carers decided that they wanted to adopt, although it wasn't an early permanence placement. And the court and the children's guardian supported the foster carers' approach, application. Lots of assessments, and there was lots of pressure put on the local authority not to move the child until all the assessments had been done, and they sort of agreed that in court, and that meant they were stuck with following through what they'd agreed. And at one stage, the court actually allowed a delay in the proceedings to allow the foster carers to go over the year, so they didn't need leave, make an application for adoption, and go past the 3 months so they could give notice for an application for non-agency adoption. And once they'd achieved that, the courts joined the foster carers to proceedings. That was the first time there was an order, and actually a concrete order, that the local authority were able to challenge. And the Court of Appeal again said it's not appropriate to join the foster carers. Care proceedings have to be decided first. So does this child need to be removed? Then placement. Foster carers, unfortunately, the child had been there for a year, and unfortunately we are finding that that's happening more and more in early permanence placements. Children are still with the early permanence carers after a year. That gives them the right to make an application for non-agency adoption, not because of their status as early permanence carers, but simply as foster carers who have had the child for over a year. If that happens, the application should be heard at the same time as the placement application, not with the care proceedings. So current position, we've still got concerns about courts and guardians not supporting care plans with EP placements, but we've got a long line of cases holding that early permanence carers are foster carers, no more rights in respect to the child than any other foster carer. And we have a line of cases which lay down the cardinal principle that the court cannot interfere in the local authority's care of the child once a care order or interim care order is made. What we don't have is a case joining the two situations up. We don't have a reported case considering a situation where a judge has actually prevented the local authority from making an EP placement and insisted on a mainstream short-term foster placement. That decision is made by a local authority following their statutory duty, undertaking reviews with IROs, and those decisions on which is the most appropriate foster placement is for the local authority. And if they've gone through their processes and decided that an early permanence placement is the best option for that child, then if you need to hold on to that and refuse to agree to shift that child to a short-term foster placement from where they're going to have to be moved again. And we're also finding that early permanence, I think there's a general atmosphere of concern about adoption. It's becoming less popular. People are more concerned about the rights of the parents. And we see the numbers of adoptions falling. I think early permanence is getting caught up in that. And we do have to hold the line. And I urge everybody to follow the statutory duty, make early permanence placements if it's appropriate, and hold on to them. And we press on.
Thank you very much, Alexandra. Thank you for that. I should have said, actually, if there are any questions as we're going along, do put them into the chat, and we'll direct them under the Q&As. That means we move on then for 15 minutes then to Vicky Davidson-Boyd, who is a service manager, I hope this is right, service manager at Adoption Tees Valley. And she's going to tell us about national developments, Vicky.
Thank you very much. And I'm just going to try and share my screen, hopefully share the right one at this point. So yeah, I'm Vicky Davidson-Boyd. I'm the Head of Service for Adoption Tees Valley, and I'm the chair of the National Early Permanence Working Group. And I've been asked today to talk to you a little bit about the Early Permanence Working Group and what that sort of strategic and operational plan is looking like. Get that to share. Bear with me 2 ticks here. So let me see. Is that sharing?
No, it isn't. But I have a copy of your slides, don't I, Vicky? So perhaps if I just put them up, and then you can do the whole next slide as we go through.
Okay, great, lovely. Thank you very much. Okay then. So thanks for that, Liam. So I'm sending out Boris Johnson now. Next slide, please. Right, okay. So that's the first one, and if I can have the next one. Right, lovely, thank you very much. So talking a little bit about the National Early Permanence Working Group, I wanted to sort of just kind of give a bit of a context for, you know, where this sits in terms of the national, very complicated system of professionals working around early permanence across England. And so what I wanted to do, first of all, was to just kind of share with you the Regional Adoption Agency Leaders Programme, and this is a strategic programme, and it is the overall plan for national, for RAA leaders in terms of taking forward adoption planning and development in its entirety. I focused on strategic priority 2 there, which I've sort of picked out in red because that is all about the journey of the child. And the journey of the child is the strategic priority, which is about regional adoption agencies and local authorities working together around planning for permanence, around reducing delay for children and effective matching for children. And early permanence sits underneath and within the strategic priority 2. So Liam, if you're able to move us on to the next slide there. Thank you. And if we kind of focus in now and look at that strategic priority 2 and delve a little bit deeper into the Early Permanence Working Group and what is sitting under the Early Permanence Working Group and the strategic priority 2. So we've got the Early Permanence Working Group, and alongside that we've also got a practice and service development group. Quite there may be people who are in the session today who've joined some of those practice development groups and have had the opportunity to kind of just move along with the work that's going on there and be involved in that. But the Early Permanence Working Group is quite widely represented. It's not just RAA leaders. So it's made up of, there are about 3 RAA leaders in the group, but there's also representation from ADCS, from Children's LA Permanence Planning Services. There's VAAs, Voluntary Adoption Agencies, representation from the Department for Education and from Quorum, and also more recently from CAFCAS as well. So it's quite widely represented group, and we feel that that really strengthens the programme and the development work that is taking place through there, because we feel that we need to have quite wide sector representation and voice in order to be effective and really look at how we do together take forward some of the strategic developments that have been enacted. So could I have the next slide, please? Okay then, so the Early Permanence Working Group really got going in 2021, and I thought it was worth just kind of really talking to you a little bit about some of the kind of big issues that were being talked about, some of the big challenges that we looked at and were facing, and what some of the drivers for change were that we wanted to look at and we wanted to take forward as a system. And it's really interesting listening to some of the speakers tonight, because these are exactly some of the things that have been spoken about tonight. But in the group, we were looking at an early recognition that there's significant variation across England in the use of early permanence. So in some areas, we knew that 35% of all adoptions were started in an early permanence placement, whereas in other areas that was as low as 3%. So there's kind of a really big variation. We wanted to kind of really explore what that was about. There was a real recognition that the data around early permanence that was being collated was probably, to be fair, quite inaccurate. There was misrepresentation, misreporting, misunderstanding about what was an early permanence placement. There was no clear-cut longitudinal research around the evidence of the impact of early permanence. And then talking a little bit more, as Jane has spoken about earlier in her session, you know, we were having those early conversations about language and its importance in early permanence, and particularly the terminology of fostering for adoption, of concurrency, and of early permanence. And, you know, there was quite a bit of discussion around fostering for adoption, sort of having with it an implication, and could be understood that the decision around adoption had already been made, when of course that isn't the case in an early permanence placement. So we wanted to kind of really steer the system towards using that umbrella terminology of early permanence to embrace the whole spectrum of fostering for adoption and concurrency. I think the other terminology I wanted to kind of just touch base on was the terminology of risk that a child returns home to. We felt that risk had quite a negative connotation with it. And actually, who is that risk for? Actually, the outcome of a child returning to birth family may be a very positive outcome for children where that decision is made based on good assessments. So as a system, we've moved on to a universal understanding that these are foster care placements still in the assessment stage. And I think it's really helpful to listen to Alexandra talking about, you know, that I liked your blue in the face, Alexandra, but, you know, these are foster care placements. They are not adoption placements in the making. They are foster care placements. And we also wanted to focus on the fact that all early permanence carers must be prepared for a child returning home. So if we could move to the next slide. Thank you. Now, of course, there was a lot of early permanence work that was already underway. Lots of regional adoption agencies were already doing a lot of early permanence work. We've seen that in some areas, as much as a third of all adoption placements were being made through early permanence in the first stages. And regional adoption agency leaders were applying to be awarded the Quorum Early Permanence Quality Mark. So for those of you who aren't aware, that's the standard of excellence awarded to adoption agencies that demonstrate the quality of their service and their commitment to delivering early permanence for children. And RAA leaders were invited to apply for some funding made available by the DFE to apply for the early permanence quality mark when they felt their RAA was ready to go through that sort of assessment process and demonstrate how they met those standards. Could we move on to the next slide? So the early aims of the working group were, and this is going back to 2021, I'm just going to touch on these lightly, but to increase the number of early permanence placements, to improve the quality of placement practice, to ensure that carers were well supported before, during and after placement, to ensure that every area of the country had equal and timely access to placements. We wanted to hear the adopter voice influencing the delivery of early permanence, and we wanted to look at potential innovation in early permanence. And as I've prepared for this session today, I look at those early aims, and I already critique the language that we've used in some of the early work that we were doing together in the National Working Group. Could we move on to the next slide, please? So one of the ways in which the strategy and the early permanence programme was being taken forward was through some funded projects across England. The Department for Education made funding available to be used for developing early permanence, meeting the aims of the National Adoption Strategy, which was basically to increase the number of children who had access to early permanence. And so the funded projects, REAs, were invited to bid for funds to develop early permanence projects. And the idea was that either consortia of RAAs or single RAAs, whatever grouping that the regions wanted to go into, would bid for funding to develop a project that was contextually right for their area. What did that particular region need in order to develop early permanence practice, and particularly thinking about the aims that the early permanence working group had set out. So they were locally developed, whether they were regional or pan-regional. Some of them were testing out innovation and innovative new practices. They were setting out to increase equal access to early permanence across the country. Some were collaborations between RAAs, voluntary adoption agencies and local authorities. And some of them were just focused on strengthening and embedding early permanence practice in a particular region. And I thought it might be just worthwhile sort of letting you know of a couple of the particular projects that were funded. One was for early permanence for older children and really testing that out as an approach and a methodology. Another was for wraparound therapeutic parenting for early permanence carers. And those projects are going to be evaluated for learning and impact. So at the moment, the RAA leaders are looking at commissioning a good researcher in order to evaluate the impact of those projects and the learning. Could we have the next slide, please? Now, I wanted to say a little bit about the Early Permanence Practice Development Group that's led by Cathy Sowden, who is an RAA leader in Together for Adoption. And this is an online practice group. It's open to practitioners and managers and really any professionals with an interest in early permanence. The sessions are of interest to promote and share good practice. They are hoping to kind of really promote quality of early permanence practice through that sharing of learning. They do set out to increase the quality of EP practice and also to address support to carers by sharing the practice that different RAAs and different projects are undertaking. And these are very well attended. It's quite typical for an attendance to be over 100 participants on any of the sessions. Just a couple of examples of some of the practice sessions that have been held: managing family time in early permanence, and understanding and awareness raising about hope boxes, which I think many of the people who are on the call today will be aware of and will be implementing in their areas. Okay, could we have the next slide, please? Thank you. So another very significant piece of work that was undertaken through the Early Permanence Working Group was the commissioning and then the launch of the Early Permanence National Standards in February this year. The Early Permanence Practice Standards were led on by Quorum and quite widely consulted on in order to develop a quite comprehensive guidance document that could be used with the aim of improving the quality of early permanence planning and delivery across England, but also in consistency as well. So a lot of work went into producing the standards. As I say, there was a lot of consultation, and it felt like a really positive step and a positive milestone to be able to launch these national standards in earlier this year, in February this year, at the Leeds Early Permanence Conference. Okay, could we have the next slide, please? So moving on, I just wanted to sort of really talk a little bit about, you know, where we were going, where the plan has developed and how the Early Permanence Group is working now. So in July of this year, we had an away day where we developed a theory of change, which was really going to kind of look at the quite complex system around early permanence. And I think on that day, you know, that was one of the very sort of formative and one of the important things that we really recognise. We are dealing with a very complex system. There are multiple agencies, there's many, many different stakeholders, and we need to really align and have the opportunity to come together to share our thinking and to work together to develop early permanence practice across England. We recognised that we needed to involve the judiciary, CAFCAS and legal teams in the overall and overarching system. one of the things that was really kind of focused on and brought into thinking during the away day this year was the impact of children's workforce turnover. It was recognised that for any single individual children's social worker who may be undertaking care planning for permanence, adoption might not feature very frequently in their casework. And, you know, we wanted to really think about that in the way that we kind of renewed and revised our strategy for delivering early permanence across the system. Communications and centralisation of information and publications was something that was felt to be really important for us to put a focus on. We heard that it was very important that actually information and some of the kind of development and the documentation that was being delivered through the funded projects should be available and shared nationally, so that we didn't have fragmented documentation across the system. There were continuing concerns, there continue to be concerns about data quality. And I think really importantly, there was a strong wish to set out that those with lived experience of early permanence should influence and inform national development. And, you know, we particularly wanted to think about parents whose children had entered care and for whom adoption was being considered. Okay, could we move on? Thank you. Now, this is a sort of really complicated old slide, and I'm not intending that people spend a long time looking at this, but I wanted to share this with you just so that, you know, you've had the opportunity to have sight of it. But this is kind of slide one, if you like, of our theory of change. And what we came out of at the end of a really hard working day was we renewed and refocused on our outcomes that we're intending. We want the number of early permanence arrangements to increase as a proportion of overall adoption. And those are for all of the reasons that Jane set out in her presentation. We know that it's good for children not to move around the system, and this really helps children with that. We want parents and carer voice and influence to shape early permanence strategy in England. And we wanted to think that early permanence should be considered for all children coming into care, not just those where adoption is a potential permanence plan. We think it has equal applicability to other kinds of permanence planning. So the orange section is our priorities for change. And again, because of time, I'm not going to go into those in any great detail. But we also spent some time thinking about if we're going to develop and revise and renew our plan for developing early permanence, we need to also think about some of the barriers and some of the things that are enablers in our work, in order to focus on those to either overcome some of those barriers and give some thought to that, or to use the enablers so that we can actually develop practice and develop awareness and the early permanence programme more widely. So that example of a barrier being that professionals may only make a small number of adoption arrangements and have little or no knowledge of EP, we felt it was really important that we gave some thought to that in our planning. So if we could move on, and my last two slides are really just to give the headlines from the plan that was developed. So there will be a website to host information and resources. We recognise the need to improve communications and consistency of information. And that website is due to launch in October this year. It may be slightly delayed. We were getting some information it will be slightly delayed, but it is the National England website, and it will host a lot of resources for early permanence. So data work is progressing. We're currently doing some work to establish a benchmark for the past 2 years around early permanence from REA leaders, but we are progressing work with ASGLB to improve the data collection criteria for early permanence. And that's really to help us really understand what's happening for children when they come into care, and including numbers of moves prior to going into an early permanence placement or into the adoption placement. The practice group is leading work on support to carers, and the funded projects are testing out support approaches. If we could just move on to the last slide there, please. Thank you. Adoption UK have completed a report on user experience of early permanence based on a fairly significant survey that they undertook. and that is being used to inform practice. And there is a small working group starting to work with the Barnardo's Pause project with some birth parents to draw on their views and feedback on early permanence. There's a goal for each regional local family justice board to have a shared early permanence plan and regularly review early permanence in their local area. And there is a plan to commission a research partner to evaluate the impact of early permanence and funded projects. And finally, we're looking at a partners in practice early permanence champions approach to strengthen learning and consistency, and to carry the expertise that is developed across agencies who are working with early permanence. So thank you very much. That's it from me.
Thank you very much. Thanks, Vicky. That's great. Thank you for that updating information. All right, we've got a comment here from Lawrence. I think an important step for early permanence is to introduce more voices of a child's birth family to the resources available for prospective EP carers. This will further develop empathy and really open the doors for considering more open contact arrangements to build more positive life stories for the children. I mean, I would, if I can put my 2 pennies worth in, I certainly think that there is a great deal of scope for a lot more cooperative working. I think actually obviously if judges are making orders they shouldn't be making, then people should be appealing them. But if in fact pressure is being brought to bear, and that's being brought to bear out of a lack of understanding of how these things work, then in my view the better way to approach it is to gather people together and educate them. And I think I'm not giving anything away. I think that when I say the research that everyone's going to be able to see in November makes some splendid suggestions about having champions, and I don't see that will push early permanence forward. And I see absolutely no reason why judges can't be champions of early permanence. It doesn't put them in conflict with anybody, it seems to me. It's over there, but so I think it's time for us to wrap up the conference. Just thank you to everybody who's taken part. And thank you for everyone who's attended. I hope everybody's got something valuable out of it. And I would suggest that if you're interested in early permanence, you get hold of your DFJ and have a word with them about it. Maybe they'll champion it for you. All right. Thank you.